You see this Trump supporter in our Supreme Court? They are next. You are next, Supreme Court, because we are tired of you. We are tired of you. Barrett, whatever, Kavanaugh, whatever your name is, you a racist. Under the Supreme Court.
The president and director counsel of the NAACP Legal Defense Fund, an attorney who argued that case before the U.S. Supreme Court, Janae Nelson, and Jelani Cobb is back with us. Janae, thank you both for coming, but I'm very excited to have you on because you were there arguing on behalf of everyone, really, to make sure that this stays in place in some way, shape, or form. When you heard what the conservatives were saying, when you heard what Brett Kavanaugh
He a fucking conservative. He shouldn't even be in the Supreme Court.
How do you think this is going to play out? Because
we got to get them out of there.
I know lawyers often say you can't try to guess what the Supreme Court is going to do, but it did not sound.
They don't go by the law. They're not doing the law. They're not going by the law. They're trying to appease Trump.
Well, listen, I think we are all rightfully concerned and frankly alarmed by the fact that we have to re-argue this case. I think it's important.
Yeah, why you got to re-argue something that's the law?
The court in March, and we argued.
This is America, made up of different people.
We had given enough reason for the court to continue to affirm its own precedent and to, do what is right here, which was to reverse the lower court, challenging the fair map that we were able to obtain.
Politically motivated, man. You see what I'm saying?
What I thought was very important is that Justice Kavanaugh seemed to be engaging on an issue that I know is important to him because he indicated as much in a concurring opinion in another case that we won, that he's concerned about time limits around the Voting Rights Act. And, I made very clear, I don't think a durational time limit is needed in a statute that enshrines a constitutional right.
Yes, a constitutional right. You're supposed to be going by the Constitution. What are you doing?
The protection and the enforcement of that right.
Do you even know the Constitution?
We'll see what happens here. I think we've made some extremely persuasive arguments as to why the Voting Rights Act in Section 2 in particular is a permanent.
You are supposed to be a Supreme Court justice going by the Constitution of America.
When we see no
what are you doing?
In the attacks on the right to
there shouldn't be no argument.
This protection is as necessary as ever, and I hope that the justices will appreciate that fact.
Shouldn't even be no argument.
Today, I want to play a soundbite from one of your exchanges with Justice Jackson on this issue of a time limit and why she feels like this is not about a time limit, but rather Section 2 being used as a tool.
It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist. And those circumstances that Congress is worried about is unequal access to electoral opportunity. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
So that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
Right.
And Jelani, what is your reaction to that exchange? And for
pay attention, America.
Maybe that might have gone over our heads. What do you think Justice Jackson is trying to communicate?
So there are a few things at play here. One of which is that the idea of there being a time limit for a racial remedy doesn't take into account the very question of why the law was passed in the first place.
Right.
And this takes us back to 2013 with Shelby v. Holder, at which point they said that there was no longer any need for pre-clearance for the federal judicial panel to have to determine whether or not electoral laws would have some negative impact on communities of color or communities that have been traditionally deprived of the right to vote. What they found was that while they were saying there was no need for this, district after district after district had in fact failed pre-clearance. That this panel of judges had found again and again and again that there were attempts to dilute the power of minority voters.
Right.
And so we see the same sort of thing here, going back to an earlier segment when we were talking about guardrails. This is a guardrail to prevent us from having the same sorts of problems we have historically had with the enfranchisement of vulnerable communities. The last thing I'll say about this is that there is an odd kind of parallel here.
Mm-hmm.
The opposition to the passage of the Voting Rights Act and the passage of the Civil Rights Act, if you go all the way back to 1964, 1965, the arguments that you heard, particularly from Southern senators and Southern legislators, was that these were racial entitlements. Not that there were people who were being deprived of their citizenship rights, but these were additional rights that were being granted at the expense of white people, I might add. And so we've seen that logic come full circle, and that's why we're dealing with these situations right now.
Never mind that it's guaranteed in the Constitution. Janae,
I
want to put up
guaranteed.
a map here that we have a Voting Rights Act protected seats at risk from the Supreme Court. I think there are 18. There are 18 of them, almost 20 of them. And then if you look at Alabama, they're trying to come up with a map that would have zero Democratic, 0 seats that would be won by a Democrat. Listen to what, again, for you, since you were there in the court, listen to what Justice Sotomayor had to say about this instance.
What you're suggesting is that people of one race, of blacks in Louisiana, who will have to be 51% of the population before they'll be able to elect another black candidate. Because what you're saying is partisanship is non-negotiable. You have to create maps where you're going to have 6 districts out of 7 always white, because that's our partisanship.
What?
That means blacks never have a chance.
Right.
No matter what their number is, until they reach more than 51%.
And of course, she's not talking about Alabama. Obviously, she's talking about Louisiana. That is the focus of this case. But I brought up Alabama and showed that map again, Janae, because using the argument that the justice was making, in Alabama, the black population, according to the 2020 census in Alabama, is 26%.
Right.
So there will never be a black member of Congress elected from Alabama, given the logic that Justice Sotomayor was just articulating.
Yeah, well, I'm glad that you raised Alabama. Alabama is another case that we won just 2 years ago. There was a case, Allen versus Milligan, that we litigated on nearly identical facts to what we were before.
Wake up, America. You see what's going on. And the Supreme Court is behind it.
We got a 5-4 decision in our
Supreme Court is behind it, and I don't hear nobody kicking nothing out of you. Y'all got to start. Yeah, nah, man. Listen, this is America. This is our country, not theirs. Not theirs. I don't care a damn who put them in the chair. This is our country.
Will not get you there. You have to have what we call the totality of the circumstances.
At the end of the day, it's more of us than it is them.
The environment in which these electoral processes occur, and whether the minority population that's constantly being outvoted is also experiencing racial discrimination in other sectors of society.
Right. That's why I said their agenda.
Power. And that's what we proved in Alabama.
Politically motivated.
That's what we proved in Louisiana.
They're not going by the Constitution.
And right now, we're
at least not Kavanaugh on them.
Backlash that Jelani described, which is white voters.
Jackson and Sotomayor is going by the motherfucking Constitution. These other 2 motherfuckers that Trump put in there, you should have known better. Trump put them in there. Anybody he put in there ain't got as much sense as he do.
When we have a fair democracy, when there's competitive districts, what states are trying to do now is to lock in a partisan tilt, and also to exploit black voters and continue to pack and crack them to ensure that they do not exercise their full political power. And that's it, full stop.
Yep.
That is directly contrary to the Voting Rights Act and absolutely contrary to the Constitution.
That's right.
Janae Nelson, thank you so much for breaking that down.